Hello and welcome to another of my series of conversations. My name is John Cornicello. I'm going live on Mondays and Thursdays at 10 Pacific and 1 Eastern. Coming up on Thursday the 13th, my guest will be Michelle Bates, known as the Holga Queen and author of the book Plastic Cameras. We'll also talk about performance photography and the switch from two mirrorless cameras that we're both going through. But today's my guest is photographer Jack Reznicki, one of the original Canon explorers of light. Jack is also the author of a book called The Copyright Zone and has written extensively about copyright issues for photographers. And that is our topic for today. So let me please introduce to you Jack Reznicki. Take it away, Jack.
Thank you. Take it away. I got it away. Let me just share the screen. Whoops.
There you go.
Alrighty, here we go. Copyright 101. This is sort of a truncated version of what I usually give. And but I'll give you an overview about copyright, and then usually if somebody's, with the exception of Jeff maybe, somebody who's going on a program like this, you probably have a question. So we'll do questions and answers, or I'll just keep going. This is the book I wrote with lawyer Ed Greenberg, and it's chock full of a lot of good information, except the registration. They've changed the registration, but it gives you information on how to write an invoice, which is actually your license, some different contracts, model releases, negotiating tips, and a lot of stuff about copyright. And we also have a blog. It's an infrequent blog. Whenever we have something we think is pertinent for people, we post something. So it's thecopyrightzone.com, a good way to, find Ed or me. So there's a lot of misconceptions about about copyright. And most of it's on the internet. There is just so much bad information on the internet. Things like, somebody stole my image, what should I do? Oh, send an invoice for X amount. Worst thing you can do, do not send an invoice. It's gonna come back to bite you, especially if you have a really good case of infringement. If you Google this quote, the problem with quotes on the internet is that they are often untrue. You'll see that it's attributed to Abraham Lincoln. That's how bad things are on the internet and following information. Let me just hide this. This is something that came up a few years ago, and it's like, oh, can I use this picture? Oh, what a great chart. It looks great. It's horrible. You follow something like this on the internet, you're going to run into problems. I mean, you know right away when you get in and you see things that are misspelled, like brochure, that you got a problem. And things like usually safe. The comment below that, yes, you can use it if you completely rework the image so it isn't recognizable from the original, or if you completely change the meaning, as you might in a parody. Most people don't understand what that means. And it's a lot of vague things like this will get you into trouble when it comes to copyright.
I know I've heard people say 10% different. I'm like, no.
No, they used to say 30% in art school, actually.
Huh.
And there is no percentage. It's a common man test in court. If you hold up one image and hold up the other image, and can the average person see that one was derived from the other? That's the actual test in court. It's just an eyeball test to see, can you see that one was derived from the other? There is no legal, oh, you crossed 30%. How do you measure that? Anyway,
and it's also unfortunately kind of capricious and subject to change based upon who's in court. That's the problem. There's no hard and fast rule.
Yeah, and reading court cases can be very confusing. I'll talk a little bit later if people want about the Cariou versus Prince case, which a lot of people said, oh, Prince won that, and no, he didn't. But it was a confusing result, and we'd like to see some of those things resolved in court, but we'd like to have a good case. There's a lot of cases when you really delve into them aren't that good. But let me continue on the overview. Civilizations come and go, and the only thing that remains after civilizations fade is the artwork, things that artists create, be it painting, sculptures. That's the only thing that remains. We don't know anything else unless it's something that artists created in many, many cases, going all the way back to ancient history. And why do I bring this up? Why do I care about what's left behind. It's the understanding that we as photographers create intellectual property. And the concept that we're creating property is important. A lot of photographers don't understand that. They think when somebody takes advantage of them that they don't have certain rights or anything. Your photographs are real property, just like a car, a piece of land, a house. And you have to go in with that understanding and attitude. Now, today's copyright laws are very different than laws we had in the past. In the past, we really didn't have laws. If you needed to make a copy of a Bible, let's say, you had a Bible and you wanted a second copy, you'd have to run up to St. Kinko's monastery and see if the monk will make it. And they'll tell you, yeah, you can have a copy in 3 years if the monk don't die who's writing it. Everything was done by hand, and it took forever to get things. So copying wasn't a big issue. But things have changed today because of modern technology and how fast we can copy things. We want to be able to protect ourselves. Today we have laws protecting us in copyright. And one of the big things is when you create it, you own the copyright from the moment of image creation. So as soon as you snap the shutter, you have a copyright. If you're a painter and you put paint to a canvas, you own that copyright. If you're a writer, as you write out the words, you own a copyright to what you create. That's since 1978. Before 1978, you had to jump through some hoops to be able to have your copyright in the US. Copyright, again, exists from the moment the work's created, but there's a big but. There's a danger and caution to that. We want to tell everybody it's worth a bucket of spit here in the United States without registration. That your copyright, while you may own it, there's nothing you can really do with it unless you register it. And that's the bucket of spit is a quote by me. So what exactly is copyright? Copyright is the right of ownership to your intellectual property. And here's the thing a lot of people don't know is that it's written directly into the Constitution. It's not going to change because people are saying, oh, it's outdated and this and that. It's written directly into the Constitution. It's Article 1, Section 8, and it says, Congress shall have the power to promote the progress of science and useful arts by securing for limited times, and I'll go into what that is, to authors and inventors, and since 1865, photographers, the exclusive right to their respective writings and discoveries. So this is in the Constitution, Article 1. Now understand, this predates all the amendments. The framers of the Constitution of our country, the founders, thought that this was so important. It's the only right given to people directly in the Constitution itself. It predates the amendments. It predates the freedom of speech, freedom of the press, freedom of religion, the right to bear arms, and of course, my favorite, the repeal of prohibition. Now, why did they see this so important? The reason is they understand that if you do not protect creative people, you do not get as much creative work. In their case, they were really concerned about writing because that was the media of the time. But they understood if you didn't protect creators, you just don't get as much creative work. So our rights, our copyright protections are known informally as our bundle of rights. And what are our bundle of rights? It's also known as your exclusive rights. It gives you, the owner, the rights to control your property and prevent others from exercising control over your property. And that's a legal term, exclusive rights, meaning they're completely within you. Somebody doesn't have a partial rights to it, or, oh, if they do this, they gain rights to it. You have the exclusive rights to your copyright. And what are the specific bundle of rights expressed in the law? It's these items. The first one is the right of reproduction. You have the right to decide if your work is reproduced or not reproduced. You could say, no, you can't reproduce it. You know, this is the only copy I want, or I'm only going to make 5 copies of this and that's all that's going to exist. You also have the right of derivatives. Now, derivatives is a very complicated thing. I can go into, I can do almost an hour just on derivatives. and different cases about that. But you have the right for people taking your work and altering it or making it into something else. There are limitations in that, and it can get very confusing because you have to your images something known as the right of the expression. You don't have a right to the idea. You can't have an idea and saying, okay, I own this, and nobody else can photograph. The idea of two hands shaking is one of the examples we give. The expression of it, if somebody copies that image exactly or copies your image, then it's an infringement. And again, I can go deep into that, but that's one of your rights under the bundle of rights. Distribution. You can say, I only want my work distributed east of the Mississippi. I only want it in the greater New York area. I only want it in Asia. How your work is distributed is one of the specific exclusive rights in your bundle of rights. The right of performance is listed in a copyright rights. It does not affect us. We don't have performances of our work. This is really for songs, for movies, for plays, for dance now. Dance couldn't have protection of copyright until they were able to write down in a specific language the dance itself. Before that, and it's been, I think it's only been about 10 to 12 years that they've had the right in writing out choreography and protecting that. Our right of performance is really the right of display. The right of display, you can say, I only want my work as 16 by 20. I only want my work as a billboard. I only want this work to be shown in black and white, not in color. So the way it's displayed is one of your specific rights in the bundle of rights. So there is also an unwritten right that Ed Greenberg and I like to talk about that a lot of photographers don't understand. It's very, very simple. It sounds very simple, but just people don't get it. And that's the right to say no. Somebody steals your work or uses your work, you have the right to say no. You cannot do that. We see this all the time when someone like Richard Prince steals stuff off of Instagram. And people say, well, I'm waiting for them to contact me to see, you know, what they're going to do. No, it doesn't work that way. People aren't going to come to you and settle things. You have the right to say, no, you can't use it. This is my copyright. And it's something I see over and over again that photographers don't quite grasp sometimes. So how long is your copyright good for? Works created after January 1st, 1978. It's for your lifetime plus 70 years. And that's fairly recent thing. It used to be before 78. It varied from different times from 28 years to 35 years, and it kept changing. But now to match basically international standards, it's your lifetime plus 70 years. So your heirs can benefit from the work you do. And there are people in this country whose heirs are still profiting from their work. Famous portrait photographers, Philippe Halsman say, his archive's still going. Ruth Orkin, I know her kids are still benefiting. So there is a benefit to having that. Ed Greenberg and I found an infringement when we were writing our book of a friend of ours who passed away. Ed was able to get a pretty large settlement from the New York Post and gave the money to the widow and his kids many years after he passed. So it does last for a long time right now. Copyright registration, what do you get from that? And why do I emphasize registration and the fact that your copyright isn't worth a lot without the registration? How important is it? Well, the first thing and the foremost important thing is the ability to file a lawsuit. You cannot file a lawsuit without the registration. The other side knows that. A lot of infringers know that if they don't see a registration form, that you can't do anything. They can tell you to go pound sand, and that's all you could do. The only thing you can do is sue someone, and you have to have the copyright registered and the registration in hand. that was something that the Supreme Court just this past summer looked at, because one of the circuits allowed what's known as an application suit to be filed, where you don't have the registration, but you applied for it. And they allowed a suit to be filed in court. I think it was the Ninth Circuit. The Supreme Court ruled this past summer, you have to have the physical registration from the Copyright Office in order to file in court. And you can only file in federal court. You cannot file in civil court. You can't go to small claims court. You can only file in federal court. And I think it costs somewhere, I think it's $400 or $500 to file a complaint, and another 100 or so to serve it. That's it. Also, the right to compensatory damages or statutory damages. Properly registered, you can get, if you register before the infringement, you can get statutory damages. If you register after the infringement, if you waited until you see an infringement and then register, you can only get what's known as compensatory damages, which is actual damages, which means what do you normally get for that? And they'll make a decision off of that number. The court will. That sometimes doesn't matter in certain cases, but you have to be a photographer getting very big fees or a very unusual situation. Generally, you want to register your work before an infringement, because that opens up statutory damages. And if you can prove willful infringement, then the damages can go up to $150,000 per infringement. And many times they use it several ways. Each time is another infringement. I've been involved as an expert witness in a case that ran into millions of dollars because of the numbers of time an image was reproduced, was used over and over again in different ways. The other thing is you can recover lawyer fees. And that's a huge thing. That usually scares the other side. Now, you can only recover lawyer fees on the judge's decision, but it has to be if you've registered before the infringement. If you register after the infringement, you lose that ability. And if it's, you have to register published and unpublished work separately. If it's published work, and this is confusing to a lot of people, there is a 3-month window from the first date of publication to when you register that you can register after the fact and be protected. It's a 3-month, not 90 days, but 3-month window, very specific. If you've registered after the fact, then you are not able to recover lawyer fees. You can also get an injunction at any point with your copyright registration, and that's where you're asking the court to take something out of the commerce stream, where if they did t-shirts or they put it on packaging, you can say, I want it out of the marketplace. You can get an injunction. Usually they don't get the stuff out. Usually an injunction is basically a wonderful negotiating leverage to get a lot of money on a quicker settlement. But that is one of the things you can get. There's also prima facie evidence, and that's just proving that the work is yours. If you've been registered for X number of years, you don't have to prove that it's your work. I just got a ding. John, is everything okay on what I'm showing? Hello?
I'm taking care of that. You can just keep going. That was just
Okay.
someone joining in.
Okay, good. Because all I'm seeing is my screen, so I have no idea if anybody's
that was
watching
just
or
someone
not.
joining.
Okay, good. Okay, so prima facie evidence also is if you are in another country. A lot of other courts look at a U.S. copyright registration as prima facie evidence that it is your work and your copyright. Now, you also don't have to be a U.S. citizen or a U.S. resident to register your work. A lot of people abroad do register their work in the U.S. because you can get more money for infringements here. And it's much more specific. There's a lot of case law on it here in the U.S. So let me move on. Now, without a registered image, without the registration, means that the possibility of bringing a copyright lawsuit is impossible, and many infringers know they can simply ignore you. I mentioned that earlier. Okay, where do you go to register? You go to copyright.gov. Do not go to copyright.com. That's a commercial site. Whoever has it now, because it keeps changing hands, is something that wants money from you probably. You want to go to copyright.gov. This is what the front page looks like. And you go to the upper right there where it says register a copyright. This is really like an hour-long session on how to fill out the form. It's not really hard, but you just have to go through step by step. But what you're looking for at the Copyright Office is something known as the Electronic Copyright Office, small e, capital CO, echo. You just follow the prompts till you get there. You'll get to this page eventually after you register your name and a password. And they change the password like every 90 days. They give you a notice that it's changing. The one thing that's changed that you have to be very, very careful of, if you look on the left to where you would go to, register a work, you do not go here where it says register a work standard application. If you go there and try and register your work there and go through the process, you will lose your application fee and your work will not be registered. And you won't find out probably for a couple of months. This has been a big problem. They're trying to make it a little more obvious. Where you want to go is here. This one, the second choice down under other registration options, register a group of photographs. The standard, by the way, would be if you had one picture, you shot something that was historically significant, some big event, and you had one image that was important, you could register it under a standard application as one image. It's slightly cheaper, but you're better off registering a group of photographs. Anything more than one, you're going to register here. Register a group of photographs. What's the effective date of your registration? The effective date is the date the Copyright Office receives all the required elements in acceptable form, regardless of how long it takes to process, because process can take a while to process the application and mail the certificate of registration. Registration, well, because of the pandemic, is even slower. They did get it up to about, I got one once in about 4 to 5 weeks. I was shocked. Usually it takes months and months, usually 6 months, 8 months. A year is not unusual to get the registration. And right now, I'm waiting for a couple I did during the pandemic, and people are working from home, so I'm guessing it's going to be closer to a year than 6 weeks to get it this time around. If you do have something where you need the registration immediately because you have a court case or something else coming up, you have something and you need that to file and pursue a case right now, you can get a registration in 24 to 48 hours, but the cost jumps up to $800 to get that registration expedited, and you have to tell the Copyright Office why you need it that fast. But there's reasons for importation sometimes, but usually it's because of a court case. You need it here and now, $800. This is what current registrations look like. They usually come just on one page. If you look, this is page 1 of 6 in the bottom, and it has the effective date of the registration. So the effective date is important. The effective date means that this is the date you're protected by. Any infringements after this date, you've pre-registered, so you're in good shape. So, and to get everything into the Copyright Office, if you know what you're doing, I used to be able to do it in about 15 minutes or so, 20 minutes when I was all set up. Now, because of some changes, it takes me usually about 45 minutes to do it, let's say, to get everything done correctly. Whoops, sorry, didn't mean to do that. So, come on, go to the next. Here we go. What you need for registration are these items. A title list, which is something new. The images themselves, which I'll go into because they should be JPEGs, small JPEGs. The registration form filled out, and the payment. And I'll go into exactly what that is. But the title list is something new that just changed in February of last year, and they've changed the form. You have to download this Excel sheet is the best way to do it. You can come up with your own, but it's a bit of a pain. And the requirements are basically, you need the case number. Once you start a registration, you'll get a case number. So you take that number and you plug it in on the top in the yellow there, and then you fill out 2 columns. The photo number will be listed already there. You fill out where it says required title of the photograph. So you fill that all out, and it's a cut and paste that I do. I have to use text edit on my Mac to get all my titles, grab them, and paste them in here. But it's, once you know how to do it, it's very simple. When you do that, the 3rd column, list of all group titles that's in green, that will populate automatically from their form. And the reason you need that is it has each title name with a comma after it. And you need that in the registration. When you enter these, they want the titles now. You enter in the titles, and to separate it, you need a comma. So they do it for you instead of you doing it one by one by one. The middle one that says file name of the photograph, that's in case the file name and the title of the photograph are different. To keep things simple, I just keep the title of the photograph and the file name the same. I don't see a reason for me to change it. So those 2 things are always the same. If you're someone who has titles to your photographs and you want to do that, go ahead. But you can title your photograph later as long as everything is consistent, you're fine. As long as you can find your picture if you need to later on. So yeah, these are the 3 columns. I didn't realize I had a close-up for my SVA class. I'm looking at that. So what you need to register are the images themselves, which are small JPEGs. They do not accept TIFFs, they do not accept RAW files, and there's no reason to send that. I do small JPEGs, 800 pixels on the longest side. I do like a 5 to 6 compression to make it really small. And then you put them into zip folders. Your folder of images have to be zipped in order to send them to the Copyright Office. You can't just send a folder, it won't accept it. Again, there's no reason to send large files. This is public information. It goes to the Library of Congress and people can look through it. So as far, no, I've never heard of any problems with that, but I just send small JPEGs. It makes it easier to upload. All you need to do is to send them big enough that you could reproduce them in court on a projector, which is what I did in one of my infringement cases. All I had to do was get the file, throw it up. So you don't need a big file at all for these things. Since February 2019, it's changed. It used to be I could register 10,000, 13, 14,000 at one registration for the same cost. It is now limited to 750 images per application. So that's $55 to register 750 images. That sucks. It was much better when there wasn't a limitation because it's, you know, I go abroad. The one that I registered for 13,000 is I went to Africa and I came back with 13,000 images instead of, waiting to edit it down to my pics and this and that. I just took the whole batch and just registered it because I didn't know if years later I'd find a gem in there. So now it's 750. So to register that many images is going to cost me a lot. So I have to edit down. Now, if you think that's bad, if you're an illustrator, if you're somebody who draws things, in February 2019, their limitation per application went down to 10 illustrations, 10 images. So, 750 is where it's at right now. Hopefully that'll change one day. Again, and people think it's per image. It's $55 per application, not per image. The exception being if you need the registration immediately. In that case, it's $800 to get it registered. So you can't mix published and unpublished images. And you also can only have one author. So if you have a second shooter or somebody shooting behind the scene things, even though it's your copyright, because you've transferred it either because it's an employee and it's work for hire, or it's somebody that has legally transferred the copyright to you. I've had this problem, and the issue is you can only have one author per registration, which really sucks also. And I'm getting toward the end of this, and I'll take some questions. Do watermarks mean anything? People saying watermark, not watermark. It's tricky. We have an article in our blog, thecopyrightzone.com, on watermarks, and we explain it more thoroughly. But basically, there's no legal protection in watermarks, but there is protections if somebody removes it. If somebody removes it outside of copyright, it's online. If they do that on something you put online, it is a violation of the Digital Millennium Copyright Act, and you can sue, even if you're suing for copyright, you can sue also for violating DMCA, which is other monies that you can get. But also, more importantly, somebody removing your watermark shows willful infringement, and that boosts up what you can collect in statutory damages right up to the $150,000 per infringement. So I think watermarks are important for several reasons. So the value of watermarks is the title of the article in copyrightzone.com. You just have to search for it. So what I do is I do not put in a huge honking copyright notice like this over my picture. It's unnecessary. I think it's ugly. It's distracting. And it looks like this little kid's growing a mustache with this. It's just not needed. All I do is you look in the lower left, a very discreet little, sometimes I fade it back. That's all I need. Removing that is just as much as removing any other copyright. All I need is a logo or something else. Plus, I want people to know if that picture goes on social media and gets shared, nobody's looking at the metadata, which you should also be very strict about. Changing or removing metadata is also DMCA violation. But if somebody removes that copyright, if they crop it out or retouch it out, that's willful infringement. And I'm happy to see them do that. So it's 2020, time to change the dates in your camera metadata. Make sure you go into your camera, and I do this every year. I want my metadata to be accurate and up to date. So I display it. There it is. If it's 2019, I'll just go in and I'll change that to 2020, which is what I did on all my cameras. With that, I think I can go on for about another 2 hours, John, but I think that's pretty good for now.
Great.
Any questions on that, on anybody that didn't fall asleep?
Yeah, published, unpublished. If I publish a photo on my blog, is it considered published?
It's a gray area, and we can't seem to get a decent answer on that. Even the Copyright Office is very vague on that. They sort of leave it up to you. In court, lawyers are going to argue that presented to the public is the legal definition of published. So if you present it to people outside of a small group, that can be considered published, presented to the public. There's some other twists in that too, in that if you're a commercial photographer and you submit pictures to an ad agency, to a group of people to evaluate your portfolio or your images for a job, that is also considered publication. It's sent for the consideration of further distribution. And all it needs to be is more than one person, 2 people. To be considered for further distribution, they consider that publication. My feeling, and Ed Greenberg, the lawyer, who's always on the extreme of things, we don't always agree on things. He says, you know, anything that you put up online, you should have it registered. And I adhere to that probably 90% of the time. Anything I put up that I consider of any value, I've registered. If it's something I did as a snapshot of something on my iPhone, like, oh, here's a food that I did, or here's a sign I just saw, I'll throw that up and I won't have it registered. But registration is I think important before. It's a cost of doing business. I've sued several times for infringement. I got enough one time to pay for my my '05 Prius at the time, and you know, that pays for all my registrations going forward. And I've had another one where I had a registration. Let's see, I got some notes. Jeff, you had something about the Mickey Mouse copyright change. That was when it extended copyright. It was also known as the Sonny Bono Copyright Extension Act. It was put forth by Sonny Bono, of all people. And that's when copyright was extended to your lifetime plus 70 years. And I think 90 years for corporations. And the reason was Mickey Mouse was losing their copyright, which they're going to. They lost the copyright
In
to Steamboat
2023.
Willie. Yeah, yeah, they lost it to Steamboat Willie, the original Mickey Mouse character.
Yeah.
But they're playing all sorts of games with trademarks to protect it. So
I've got a question in the chat here from Melissa, whose screen froze, but can you help me understand what unpublished is? For example, I'm a senior portrait photographer. If I never post a gallery of images but post a preview of one image, does this mean that my other images can't be registered?
no, that should be okay. A preview of one image is all the other images can be registered. Listen, it's a gray area, and it's going to be up to a judge in some of these things to decide. And the thing you're not going to hear from a lawyer is, go ahead and register it. You know, let the judge decide on these gray areas, because there is no clear-cut thing. If you're a commercial photographer and the work's very important, then that's really important. If you're a senior portrait photographer, you're running into another problem in marketing, and it's practicality. Are you going to be the portrait photographer shooting seniors, which is very lucrative, by the way? I think one of the most lucrative areas in photography. If you're shooting senior portraits and you register your work and somebody copies it, are you going to go after them and sue them for copying their senior portrait? Your reputation in your town is going to die quickly. You need to figure out how to market your images from senior portraits in such a way that you're getting your money up front. And if I know some guys do things like they tell their the kids, if they're doing a senior portrait, look, if you leave my logo on the portrait, I will give you one that you can use for social media for free. If you remove it in my paperwork, you'll see that I'm charging you $100 or $200, you know, just something to scare them off. You don't really collect it. But senior portraits, I think, is something you have to, I think, be a little careful with suing somebody for infringement. You know, you have to consider other considerations sometimes. I'm aggressive on it. I think it's important not to let people get away with it. There was one online lawyer who's a, quote, photographer / lawyer. Anytime I see that, I get real nervous, because usually they're not good at either profession. But this online lawyer who is very well known for a long time once said, oh, you know, contact the infringer and, you know, maybe it has potential work, you know, that they might give you. And I said, that's the stupidest thing I ever heard of. Somebody infringing my work, that's not a client I want. That's not a client I need. I will sue their ass off. I am not going to go into a discussion with them on, you know, oh, you know, gee whiz, you know, if we can settle this and you pay me a little bit, you know, oh, you're promising more work. I had one like that. I had an infringement, actually a niece of mine found in People magazine, one of my images. And she said, oh, you know, I think this is yours. And I said, it probably looks like one of mine. It was a kid shot. She sent it to me. And this was before I used Ed Greenberg a lot, and I was doing things on my own. And I looked at it, and it was an infringement. Somebody had rights to it through something else, but they didn't have rights in a consumer magazine like People. So it was somebody that I had sort of some work with. And what I did, and I wouldn't recommend to do this all the time. I'd rather go through a lawyer and just let them handle it. I find it's much simpler. But what I did is I sent an invoice that said, you owe me, I think it was like $5,000, because that was what the going rate was. Schmuck that I was, I probably could have gotten a lot more. I said, here's an invoice for $5,000, and it needs to be paid in 10 days or this invoice is null and void. And I got a call from their accounting department. Why did you say null and void after 10 days? We don't get that. I said, oh, easy, because then I'm going to sue you for a lot more money, which is really, in hindsight, what I should have done. The owner of the company, the CEO, called me and he said, oh, listen, we love your work. Everything's great. Listen, if you give us a break on this, we have some more work coming up. I call that the wimpy defense. I'll gladly pay you Tuesday for a hamburger today. And what that is, the work is never going to come. And I knew that. I said, tell you what, pay me the $5,000 now, because it's due tomorrow. Pay it to me now. And the next job you give me, I will give you a huge discount. In other words, you turn it around. They called and asked, could they FedEx it to me a day later? And I said, no problem. So it came on the 11th day on FedEx. In hindsight, this was in the early days of me really delving deep into copyright. I made a mistake in doing that. I think the technique was good, but knowing what I know now, I could have collected easily somewhere between $30,000 to $50,000 if I used a lawyer, because I have done that.
Jack, I have a question for you. I came into this late.
Hey, Michael.
For some reason, I couldn't get in. It wouldn't let me in, and I thought you had something to do with it. But anyway.
It was me, Nuller.
Oh, it was you. Oh, okay.
That filter isn't working. That Nuller filter is just.
I didn't feed it gerbil. That's why it wasn't working. I've been clearing out or cleaning out my files, and in doing so,
as a lot of us have been doing, yeah.
In doing so, I found a shitload of images that I never registered.
Right.
Old.
Right.
Kodachrome.
Right.
But
Nice.
now I find that I'm using them, I'm scanning them, and I'm using them for other things that I'm doing now.
Right.
But I need to register them.
Yes.
How do I do that economically?
Well, what I'm doing now is I'm doing camera scans of my old negatives. I've been posting, if you've been following anything on me, a lot of my old black and whites from the 70s. If they are unpublished,
right,
I can register them today as unpublished. And when I post it, I put a 2020 copyright notice on it. The correct notice for copyright is Circle C, the year, and your name.
Right.
It's not necessary, you just have your name, but the correct copyright notice is Circle C, year, and that. So the old 70s black and whites that I'm showing, I'm registering now, either 2019 to 2020, but it's a current registration if it's been unpublished.
Right.
And that's a common thing to do. Now, what I'm also doing is camera scans. I'm using an LED light box as a light source. And I'm using, for my negatives, my Epson scanner holder, because it holds four strips of 6. And I'm using a Canon camera with a 100 macro. I have 2 setups. At home, I have a Kaiser copy stand, which I love. Here in the country, I have a sidearm on a Gitzo. And I photograph the negatives or the chromes or the color negatives. I don't have too many color negatives. In Lightroom or Photoshop, you can simply reverse the curve. You just take the curve and, where it goes from upper, lower left to upper right, you just switch it. So the left is on top and the right is on the bottom. I also found a software that is really terrific, Negative Lab Pro. And that's been doing a great job, especially on my black and whites. It's good for color too, to get you started. But the black and whites, I find that it's a much better starting point than when I just reverse the curve.
So in other words, you take you gang them all up on.
No, I
however-
do them one at a time. You
No.
can gang them.
But when you send them to the copyright office,
Right.
you gang them up like we used to do in the old days with contact prints. All right.
No.
One at a time.
One at a time. You could only register 750 at a time under one application.
So if you do it that way, you're doing 750 sheets of paper.
No, 750
No.
JPEGs. You missed the
JPEGs,
part.
small JPEGs, yeah.
Okay.
If you watch this when John posts it, I think you'll get that information, or just send me an email and I'll go over it with you.
Okay. Now, in one of your images on the PowerPoint presentation, you showed the copyright notice, your name, and then the date.
No, it's the opposite.
No, I know it's the opposite,
date.
but that's what you showed.
No, I don't think so. Oops, I can't take that. Believe me, it's if I go back to it, I mean, I can go back to it if you want, but you'll see. It's where is it?
And on the
Here it
Mac,
is.
Option G gives you the copyright sign.
Right, exactly.
See?
So, no, that's in.
Now show
that's
it.
in the camera.
Okay,
No, that's in
but-
the camera.
But show it
Yeah,
as a copyright.
yeah. See down in the lower left.
I can't
That's
see
the
it.
proper
It's-
way to do it.
Image is too big.
Oh,
Well, you can see
it's,
it.
yeah,
It says
it's Circle C.
Circle C 2020 Jack Reznicki.
Yeah. So
Really? Okay.
in the camera, it's something else.
Yeah.
I mean,
You don't need
I
the
don't know why I
word
said yeah, I can't do a Circle C in the camera, but you know something, that's a good point, because if that is what it is, yeah, I guess I did this just because it's easier to get to, it's quicker, but this is, yeah, I should probably change that.
Do you need the
Good
word
pickup.
copyright spelled out, or was that something in the past?
No, it's just another way of doing it.
Okay.
Since I can't do the Circle C.
Yeah.
And by the way, that is an acceptable form. Did I stop sharing? Yeah.
Yes.
Yeah, writing out the word copyright if you can't do a Circle C is just as acceptable as
Okay.
having a Circle C. There's no difference in the eyes of the Copyright Office.
And what
But
happens
again-
if some of the images that you want to register now have been published?
Separate.
You have to register that separately, and it
Okay.
has to be registered. They're going to want to know the first date of publication.
Okay.
You know,
And that's
and
one
where.
at a time. That's one at a time, isn't it, Jack? Published?
Yeah, one at a time. The same way, the publication date and that information can be in the title. You know, and that's the way they want it.
Oh, and by the way,
it's
he just reminded me of something. Some of the images that I never registered, the reason why I never registered them is because they say copyright Jeff Shiwi. And I didn't realize it. You remember? You remember?
Oh, yeah.
Oh, and he did that to me, and he did that to Seth Resnick.
Well,
Right.
Seth Resnick
No,
did it to Greg
Seth
Gorman.
started. Yeah,
Yeah.
Seth did it to Gorman. I
Seth
remember
started
that.
it to
Yeah.
Gorman.
I mean,
We were passing a camera around,
right.
and so Seth called up Greg and said, Greg, look at the images. I think it was a 1DS.
Yes.
Look at the images and the XF metadata. Who owns that? And so Greg looks at the metadata and says, copyright Seth Resnick. And, and Greg was apoplectic, you know, because he gets a little over the top. And so he was like really upset because it's not an easy fix because it's embedded in the XF metadata. So it was funny. But yeah, I did that to you because I gave you a digital camera and you didn't change it.
That's exactly
yeah.
right. I figured you took it off before you gave it back to me.
No, I didn't think of that. But that wasn't on purpose. That was an incidental contact. But what Seth did, he did that on purpose because he wanted to see if Greg would know.
He wanted to screw everybody's mind.
Yeah.
So does anybody else have any questions? If you have
So, Jack,
infringements?
Yeah,
Yes,
I have a
James
question.
Taylor.
Yes.
Yeah.
So there's some, I work with more with people in the film business, screenwriters and producers, and there's a huge amount of confusion out there. I'll give you a very good example. I have a producer in Australia who's going to do a show in feature film in the United States. He sent me the script. The script is set up like scripts are set up. It says, Registered Writers Guild of America. Okay. And I got him, we were on the phone on a Zoom call. I said, hey, you got to copyright this. He said, well, I already did. I sent it to the Writers Guild. And it's like, no, you know, and people don't get it that there's a registration step that's not with the Writers Guild, and this is just for scripts. Any ideas on that? I mean,
No, you're 100% correct. That quote registration, which shouldn't be called that. Yeah, they're registering with the guild, you know, as to their script and who gets the credits. But if they had to sue somebody, that paper means nothing. That registration means nothing in court.
they don't get it.
It has to be from the Copyright Office, you know, the Library of Congress.
Jack and James, one of the problems is that the U.S. is somewhat unique in requiring a copyright registration with the Copyright Office to even enter into a lawsuit or file suit. That, due to the Berne Convention, that's not the case in international copyright law. In international copyright law, there is no registration requirement. So the registering the manuscript with the Writers Guild is proof of authorship, but it's not actual copyright. And that's one of the important distinctions that Jack mentioned was if you have a registered copyright, it's de facto, the registration is de facto proof that you own the copyright. Because quite honestly, prima facie, if you don't have the registration, well, first of all, you have to prove that you actually created it, and that puts the burden of proof on you, not the infringer. And quite honestly, that registration is golden. The fact that I had registered copyright in multiple cases of infringement, basically the opposing company's attorneys said, well, it's a registered copyright. You infringed it. He's got proof that he's the author of the image. The only question is how much it's going to cost you. You might as well settle. So I've only filed suit once, and it didn't even get to court. Most cases where, and my most infringed image is Globe Hands, and it's a registered copyright. And I have an attorney that has created a really nice, very scary letter that I send out to infringers that basically say, this is what's going to happen, and ask your attorney, and then get back to me, and we'll settle. And every case I've been able to settle.
For you.
Because it's the registration is the prima facie proof that I'm the copyright owner, and so the question is going to court is only going to be for the purpose of determining how much it's going to cost them, not whether or not they're going to get a judgment against them.
Yeah, I will say that probably 95, 98% of infringement cases are settled. Very, very few go to court. Mine never went to court. We've always settled. I did go to court as an expert witness in somebody else's case. That was a major case. And in the end, they ended up settling as all the experts' testimony came in and everything else, which was real interesting because I was on the photographer side and there was another photographer who was on the other side, who's somebody I knew, but that's another story. But you do want to have a good, and you want to get a litigator. You want somebody who's actually litigating, with one exception. There's one guy in New York who's been labeled a copyright troll He tries to go to all the photo conventions. He had a booth at the last PPE. I've tried to tell them, and I've told other people, he's been barred from places like PPA's Imaging USA. He had a booth. He tried to have a booth there one year. I don't know if he did or not, but I know he's been barred. And you can read about him. You can just Google copyright troll, New York, and he's known throughout the country. He claims that he's filed more copyright suits than any other law firm, and he's right. He's very young, and he's filed more than anybody else, and the courts have labeled him a copyright troll. He doesn't know, it appears he doesn't know what to do once something gets into court, because that's what some smart lawyers are doing. They're saying, fine, let's go to court. He's been sanctioned. He just got sanctioned $100,000. He had one case where the photographer sued, didn't even know he filed suit, which was real interesting in Chicago, actually, I think, Jeff. The photographer who sued for infringement was fined by the court the other side's lawyer's fees, like $40,000. And he wrote a letter to the court saying, I didn't even know this thing was filed. I never gave permission to this guy to do this. He files trying to pressure people into settling. That's his game. And he had one with a photographer named Mick Rock, who he filed because somebody infringed the work, and this lawyer screwed things up so badly that Mick Rock had to pay the other side's lawyer's fees of $100,000, and this lawyer was sanctioned $10,000. I'll give you his name. You can look at it. You can just Google him and see all the information. Richard Leibowitz. But any lawyer you want to hire.
I remember that.
Yeah, if you start Googling him on the internet, you'll get all the information you want. We have some articles on our blog, The Copyright Zone, if you do a search for his name. He's a lawyer that lobbyists in Washington who are going for our best interests are seeing the other side holding him up as an example of the bad parts of copyright. He's working against our interests. And
so here's
even
the question. That's a question.
Mm-hmm.
Sure.
So now all these years later, all these decades later, Jack and Jeff, is copyright dead?
Oh God, no! Like
No. I said that with tongue in cheek. John, did you show the little card that not the card, but the invitation I sent you on email from years ago?
No, I don't. No, I haven't shown it.
With the archaeologist tool and the symbol of the copyright?
No,
I know the image. I
You
know the image, Mike.
Huh?
I know the image.
Yeah, I think Shiwi did it.
Yeah,
It was you and Shiwi and Seth giving a lecture on is copyright dead.
Right. Well,
It's gotta
you missed
be
the beginning part. You
close to
missed the
30
beginning
years
part
ago.
of this. Yeah, you missed the beginning part of this where I pointed out that copyright is the only right written directly into the Constitution, that it actually predates all the amendments like freedom of speech, the right to bear arms. Those
Really?
are all
I
amendments.
didn't realize that.
Copyright is Article 1, Section 8 of the Constitution, and is the only right given to the people in the Constitution itself. Before the amendments usually cover those things. The Constitution is how the government runs, but a right to the people is copyright. One other thing about lawyers, because I'm going to backtrack real quick. Do try to get a local lawyer. It's important. Do get a lawyer who actually litigates copyright infringement cases. Don't just get your cousin's neighbor who just graduated law school. It's a complicated thing and it can really screw up. Also, the other side, I found this from Ed Greenberg. He said the best thing that happened to his practice is Google searches. He said what happens is the other side searches him and they see that he has been in court, in federal court, on numerous copyright infringement cases. That speeds up the negotiations quite a bit.
Ed is a very scary guy. I love him. I'm sitting around eating and drinking with Ed, but there's no way I would want to be on the opposite side of a court case litigated by Ed Greenberg.
Yeah, he's aggressive. He's very aggressive.
Yeah, not only is he going to win, he's going to make it incredibly painful. The whole process is as painful as possible. And tell me I'm wrong.
So
no, he's an interesting character for sure, and he's a very good lawyer. He's one of the specialists in this. But he would also recommend, unless you have a case, in one of the areas that he's in the bar or whatever, or unless you want him overseeing a case, you really need a local lawyer to do your
But
case.
somebody that
in many
specializes
cases.
in intellectual property, and more so copyright than patent, because that's
Exactly.
a separate issue and deal.
Well, funny, the one that I was involved in, an expert witness, they hired me, and then I asked for some paperwork, and they didn't have it. And I said, why do you want it? And the more I got into it, I realized this was one of the best law firms in California for motion pictures. And that was their specialty. And they were very expensive, and they didn't understand still photography. That's why I didn't have, I was asking for model releases. And what happened is the photographer eventually switched law firms. And when he did that, the case settled fairly quickly. Otherwise, it was being dragged along. And again, it was for millions of dollars. It was an interesting case in that, well, I can't get into that. But you do want to research lawyers. And if you can't find one, don't call the local bar association. They're going to throw somebody at you who needs the work. What Ed and I recommend, and it's on our blog on how to hire a lawyer, is call a local law university. Get a local law school and ask the instructor there on who they would recommend for intellectual property like this. And there's a lot of benefits in doing that. You'll get a much better recommendation that way than calling a bar association. Or ask around,
What is your-
but do research.
So what is your understanding of the new Small Claims Copyright Act that we're hoping to get passed?
The CASE Act. I'm for it, but I think there's a misunderstanding to a lot of people about it. It's been watered down quite a bit by the other side. There's a lot of people who don't want to see our copyright strengthened. And they have quite a big lobby, and we have, can afford lobbyists. It's a good thing. It would be good for photographers. Two things of note. One, your work has to be registered. In order to, it's not a small claims court. That's an important distinction. It's a small claims process. It's pretty much arbitration mediation. The problems with that is you can get somebody deciding the case who has no expertise in copyright. It doesn't mean that you're going to get somebody who really understands the law. So your work has to be registered, and two, the other side can simply decline with no prejudice, meaning they could say, nah, I don't want to do this, take me to court. Honestly, in my personal opinion, I'd rather go to federal court. I'd rather have a suit in federal court. It's the filing fee is like $500. When you get into something like arbitration mediation, you're paying the arbitrator. This one I think has limitations, but there's limitations to what you collect. You don't need a lawyer. I think it's probably advantageous in some really, really small cases, but if you have a good case against a large corporation, I would be hesitant to use that process. But again, got to have your work registered. The other side can refuse it to enter that without prejudice. And two, if you file in federal court, they have to answer. There is no, no, I don't want to do this. So in court, you are compelled to go to court. You are not compelled to go into this process from the CASE Act. I do think it's beneficial. I would support it, but understand it is not small claims court. it is not going to resolve certain issues. Good question, though.
Oh,
It's
great.
down to a final few. I think that's about it.
Yeah, I think,
And,
does anyone else
again,
have questions on this subject? This has been
One
great.
quick question, Jack.
Yeah.
Do we know anything further about Warhol versus Goldberg?
no.
Is he going to go forward?
I'm sorry?
Is she going to go forward?
I think she wants to. Quite honestly, it's a very, very technical case.
Yep.
And I love her. I think she's terrific. I think her work's great. I think she's gotten screwed by Warhol. Understand, she's not putting the case forward. She was sued by the foundation
To get a
she
declaratory judgment, yeah.
Yeah, she doesn't want to be in this. It's an expensive thing. And quite frankly, her lawyers are putting up a good argument. And every case is fact specific. I read the papers on this, and in some cases I can say, oh, nothing's ever a slam dunk. I would say really good percentage that the photographer is going to win. This is clearly an infringement, but the argument they're putting up for fair use on this, because it altered the feeling of the image, and the fact that her image is just a portrait that is just a head and shoulders makes it difficult, because she has to argue what she's added into the picture beyond just recording a face. And the other side is saying that they've added a different dimension to it. And because of the slight changes made, it's going to be very, very difficult. Unfortunately, I feel for her. Again, I'm a fan of her work, and I know her. I think she's terrific. I hope she comes out well in this. She's really being screwed by the foundation, who's being extremely aggressive and spending a lot of money on some very smart lawyers.
Yeah, so for those of you that don't know the story, Greenberg photographed prints, and Vanity Fair basically licensed one of her images to use as artistic reference for an illustration for Vanity Fair, and apparently it was Warhol. But what happened was Warhol ended up, because he spawns multiple iterations, he spawned off 16 additional copies of the image above and beyond what was in Vanity Fair. And when she contacted them regarding their infringement, which was clearly an infringement, they actually sued her to get a declaratory judgment, claiming that the work that Warhol did was sufficient enough to basically transformative above and beyond just a simple derivative right. Photography is particularly interesting in that you have the copyright to the original photograph, and then if you manipulate that photograph, you can have a secondary copyright, which is considered a derivative right, so that I, as a photographer, could work with a retoucher or a digital artist, and hopefully in collaboration and with permission, so that the derivative right could be separate and stand alone from the original copyright. So what they were basically saying is that Warhol added so much more to the image that his copyright basically kind of went upstream, which is fucking bizarre, to the point where, they wanted to make sure that the foundation, and I understand what the foundation is doing, but I think it's slimier than hell.
Yeah, I couldn't agree more. These things are, it comes down to the difference between influence and infringement and copying. Also, that's a different subject. It's not exactly about this case, but I show some examples. Like when I started out in photography, I was heavily influenced for one period of my career by Norman Rockwell, because comedy was big in advertising, and I was shooting all these characters and colorful scenes, costumes and things against white, Americana. but you couldn't look at one of my pictures and saying, oh, this is a reproduction of a Norman Rockwell. That is fine. That's influence. We're all influenced by other works. If I took a Norman Rockwell illustration and I tried copying it item by item, then that would be an infringement.
That's sort of
Let's see
like
if
the
I can-
Coons situation with the dogs.
Yeah.
Yeah, Jeff Koons and the dogs. I mean, I have images of that. Like I said, these types of things I could do a whole different presentation on. Let me just see if I can find.
How about that photographer,
thing
what's
to
his
show.
name, Andrew Luck? Where he was taking images from all sorts of photographers and doing some sort of like a collage, and he had a shop in a lot of different malls around the country, making a fortune. Was his name?
Look, yeah, no, that was all his own images. He made a bloody
No, this
fortune.
is something else, Jack. This guy was it's appropriation art. He was appropriating stuff online, blowing it up and making large prints
Right,
off of the stuff that he basically stole on the internet.
right.
And
Well, that's you're talking about Richard Prince.
Prince,
Here,
yeah.
Yeah.
Hold on a second.
okay.
Here, let me get into this. Let me get into a share screen again. Hold on a
Sure.
second.
I'm getting seasick because of Jack's computer is moving up and down.
Oh, sorry.
No, it's funny.
Okay. Here, there's a famous Carew versus Prince case, where Patrick Carew shot the picture on the left. Richard Prince did what he did on the right there. There were about 15 images, 12 to 13, I think, images went to court. Richard Prince lost badly in lower court in front of Judge Batts. I mean, killed. It was the amount of money he had to pay and everything. He appealed, went to appellate court. Appellate court said, no, some of these are transformative and they're new works, so there's no suit. But 5 of them are not transformative, and we're sending those back down to the lower courts to sue, to come up with what he owes. At that point, Prince settled with Carew. So we really don't know the final result of this. Even though if you look at art books, they're saying, oh, Prince won this case. He didn't. And this is the criteria for fair use. This is the one you're talking about. This is Richard Prince took these images off the
Instagram.
Instagram, wrote some things on the bottom, blew them up big, and sell them for like, who knows, 15, 20,000. He sells things for incredible amounts of money, probably $50,000. The problem is a lot of the photographers simply didn't sue him. They don't know how. They were upset. They cried on thing, except for this guy. There were 2 guys. One of them was Donald Graham, who's a well-known fine art photographer. This case is still going on in court. It looked like Prince was going to settle with him. And then something happened. I guess the settlement blew up. And as far as I know, this case is still in court right now. Donald Graham versus Richard Prince. Donald Graham has these registered. He's a fine art photographer. He gets a lot of money for his work, and it affects the value of his work. So they're arguing this in court right now. Everybody else,
He's got a really good case. It's
yeah,
registered.
he does.
He could prove damages, and it's very clear that Prince is exploiting the art of and original art of somebody else.
Yeah. No, but these cases are complicated. I mean, this is the other one. Art Rogers, a photographer, had this photograph. Jeff Koons made the sculpture of it. Art Rogers sued. Art Rogers won. They said, doesn't matter that it goes into a different media. It's a clear infringement. And this is a seminal case. This is a very important case in copyright. So when people saying, oh, he created a painting of my photograph, it's a different media. No, it doesn't matter. Change in media doesn't matter. It's the protected elements. But you got to be careful. Jeff Koons also did this. And this ran, did he plagiarize this toy? No, he didn't. He actually had permission. You find out that sometimes even Warhol, after he got sued for just using people's images, 3 photographers in particular, he settled with them. And after that, he realized all he had to do was either ask permission or pay a licensing fee. But this stuff happens all the time. I will show you one that drove me a little crazy. Oh, I can't seem to get out.
You mean crazier?
Yeah, this was PPA. Let me just. I'm not going to show this whole setup because I show a lot of Norman Rockwell things. Can you guys see my screen?
No, you're not sharing at the moment.
I'm not sharing. Okay, I gotta. Let me get to this and share. I'll show you what is a very clear infringement, and photographers don't get this. Okay, here's just a couple of old pictures of mine that I did in this Norman Rockwell type of feeling. I was doing a lot of stuff for Reader's Digest and did a ton of these types of images. Married Life, as we know it. The cover of Time. So this was a cover of Professional Photographer Magazine in April 2017, and they called April their Copyright Awareness Month. I looked at this and fell off my chair. This is a complete infringement. The photographer said it's homage to Norman Rockwell. No, it's not. This is the original Norman Rockwell as it appeared in the Saturday Evening Post. These are the 2 images next to each other. And why is this an infringement? Because as a lawyer, if I was in court, all you have to do is saying there's nothing added. It's a complete copy, like the cab driver on the left. Same type of hat, still same type of pants, halfway up his calf, white sneakers, same positioning, same posing, same keys out of his back pocket. Girl has a ribbon on her back, same bow in her hair. The guy with the pencil behind his ear, blah, 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 blah. A lawyer would go to each and every point and point out how each one was copied. And that's a problem. This is an infringement. It's no homage. It's a copyright infringement, plain and clear. Now, this is another Norman Rockwell. And this one is a well-known one. You know, it's cop looking over. Well, this appeared in Mad Magazine. This is a parody. The fact that this is about Trump sending military gear to local police departments. So it's based on the same thing, but it's completely legal as a parody. And it's commenting on a political situation. So it's making a commentary. It's a clear parody. Even though a lot of elements have been copied exactly, it's perfectly legal. So a lot of these things can be very, very confusing. They're not clear cut. You have to look at each one on its own value. Oh, there was one more. This is a good one too. I'll share one more because this is someone we know. Where is it? Am I sharing screen?
Not yet. There it is.
Okay. This is probably the most famous jazz album ever done, Miles Davis Kind of Blue. Huge thing. Photographer is Jay Maisel. Some people may not realize it. The image on the right was something somebody did as a tribute album. He created this computer art, he called it. I can't remember. Andy Baio, that was the guy's name, Andy Baio. He paid licensing for the music that he did for this tribute album, but he didn't pay for the photography. And Andy Baio, by the way, was like the chief financial officer at not Google, at Yahoo or something like that. Chief technical officer. In other words, he was way high up, had tons of money, and they kept trying to say Jay was this rich New York photographer trying to sue him. They ended up settling, and they settled for just over $32,000. And I asked Jay, you know, you could have gotten a hell of a lot more for this. And he said, yeah, but they decided instead of spending money on lawyers, they would just come up with a settlement fee. But Andy Baio kept saying that this was a completely different piece. You know, it would have gone to court, and the court would have had to decide. He said, what we did was not just copying, it was creating something digitally completely different. So you're going to get people with all sorts of arguments about infringements. It is a complicated issue. With that, John, unless, yeah, okay. Yeah, I hear you.
One quick question. Can you look right at the camera and smile?
Because you want to get a capture?
Yeah, I just wanted to do a screen capture. I've got a bunch of them already, but a lot of them are with your mouth open and your eyes crossed. So I just wanted
this is serious. It should be like this.
Okay, good. I got that one too. Thank you.
Here we go. I'll give you one of the.
Yeah.
Oh, wait. Got it. Thank you.
Cool.
Well,
Thanks,
you all.
John,
Thanks for coming. Hopefully you guys got something. If you can always reach me, on email if you have any questions.
Check out the website, the
Copyright Zone.
copyrightzone.com.
Yeah, it's a pretty bare basics site, and we don't spend a lot on it, as you'll see. But the articles are very different. It's things that you won't read somewhere else. And funny enough, a lot of our followers are law firms, is what we found out, because of the way we illuminate certain subjects. There's some things like when people went nuts about that case where the judge ruled that images taken off the internet were fair use. We read the court papers, and it was very enlightening. What the judge basically said is, I cannot judge anything that isn't presented before me. And that's a legal concept where if an argument isn't made, the judge can't pull it in. It's considered abandoned. The judge was basically saying, the lawyer screwed up, and this is the judgment I have to make. And it got worse because we found out that there was a company called Pixie, which is one of these firms that looks for images for you and will sue for you, supposedly, which is a horrible thing once you get involved with it. They work with not good people, and they hired a lawyer who screwed up the case, basically. They appealed it and won, which was no surprise to anybody. But reading what the judge actually said as opposed to the headlines that you read gave us a completely different picture about the case.
Hey, Jack?
Yeah.
Would you like permission to use the copyright symbol photograph that I did for that mailer that Nuller mentioned?
Oh boy, I'd love to. That was one of the best outstanding images of this type of thing I've seen. Yeah, I would absolutely love it.
All right, I'll license it to you.
And I know what it's going to cost too. A very good bottle of wine.
Well, I'm actually sober these days, so I don't drink. But a really good, really good Jewish deli corned beef.
Good.
The next time I get
pastrami. Either pastrami or a really good sushi restaurant I know near my place.
Or sushi. So yeah,
your choice.
I'll license it for dinner.
Sounds good. Looking forward to paying for it.
Okay.
Can you see that?
There it is.
Yep.
Yes.
Yeah.
There it is. What's the date on that?
2001, it looks like. Yeah.
That's it.
2001.
Yeah.
It's 19 years ago, and we're still talking about it.
Oh yeah, it got me started on it. Alrighty, well, thanks,
Cool.
John, for putting it together.
Thank you. This has been
A
great.
lot of fun.
I'm going to stop the
Metadata.
Facebook, so let's do that. Stop the
Thanks,
live
John.
stream.
Thanks, Jack.
We couldn't have gotten by without one of those.
I didn't realize it was still recording.